You've finished your investigation. You've written your report. Now it's time to take the stand. Welcome to Module 15 of our Digital Forensics video series, where we focus on the courtroom side of cyber investigations, expert testimony. This is where your technical expertise meets the legal system, and your credibility, clarity, and composure are just as important as your forensic findings. Before we jump in, take a moment to subscribe, and share this with anyone preparing to testify in a digital investigation. And here's today's question. Do you think today's jurors are equipped to understand digital evidence, or should we change how it's presented in court? Drop your thoughts in the comments. Let's begin by understanding your role. If you're called to testify, you might be doing so as a fact witness or as an expert witness. Fact witnesses describe what they observed or handled directly. They stick to the what. Expert witnesses, on the other hand, bring their specialized knowledge to explain the why and the how. They interpret evidence, offer conclusions, and are often pivotal in helping the court understand complex data. But make no mistake, testifying as an expert is not just about what you know, it's about how well you can communicate that knowledge to people who likely don't share your technical background. Preparing to testify starts well before you enter the courtroom. You need to understand the theory of the case, which is essentially the narrative the attorney is trying to prove. Ask yourself, what are the key claims or defenses in this case, and how does your analysis support or contradict them? Review your evidence thoroughly. Go over every file, every hash value, every log you analyzed. Re-examine the methods and tools you used. Make sure you can explain not just what you did, but why you did it that way, and what those choices mean for the reliability and relevance of your findings. Your documentation matters here. Every decision, every software version, every step you took must be traceable. Chain of custody needs to be airtight, and your terminology should be accurate and consistent. If you can't reproduce your results or explain your reasoning clearly, the opposing counsel will have a field day. Next, let's talk about your CV, your curriculum vitae. This is the document that outlines your qualifications, and it can either reinforce your credibility or raise red flags. It should include your education, work experience, certifications, courses completed, previous testimonies, publications, and other relevant professional activities. Keep it updated. And here's a pro tip. Don't list every book you've ever read. If it's on your CV, the opposing attorney can ask about it. And if you can't defend the content, it could backfire. You also need to prepare how you'll explain key forensic concepts. Terms like hashing, slack space, file metadata, and bitstream image may be second nature to you, but not to the jury. Practice translating technical terms into everyday language without oversimplifying. Analogies can help, but clarity is king. Let's talk about what happens when you actually take the stand. In most trials, you'll be called by the attorney you're working with. They'll present your qualifications and ask the court to accept you as an expert in your field. This is called voir dire, and it's when the opposing side can challenge your credentials. Once qualified, you'll go through direct examination. This is where you explain your findings, methods, and opinions. You'll then face cross-examination, which can be the most challenging part of the experience. The opposing counsel's goal is to test your credibility, your objectivity, and your ability to defend your conclusions. They might press you on your methodology, try to confuse you with rapid-fire questions, or twist your words to suggest bias. The key here is to stay calm. Don't guess, don't argue, and don't get flustered. If you don't know something, say so. If a question is misleading, ask for clarification. The jury will notice if you're honest and steady. Now, you may be asked to participate in a deposition before trial. A deposition is essentially a recorded question and answer session with attorneys, typically in a law office without a judge or jury present. Everything you say is transcribed, and it can be used in court. Think of it as a practice run, but one that's very real. Opposing attorneys use depositions to probe your understanding, test your patience, and prepare strategies for trial. Be just as professional and careful as you would be in court. There's also something called a testimony preservation deposition. This is used when an expert might not be available during trial, and their statements need to be recorded in advance. In these situations, everything matters: tone, clarity, and how you support your opinions. And don't forget about hearings. These often happen before the trial and are used to decide whether certain evidence or expert testimony will even be allowed. You might be called to explain why your methods are valid or why your findings are relevant. While less formal than trial, hearings still follow rules of evidence, and you must be just as prepared. One of the most important things you can do throughout this process is to work closely with the attorney who called you. Review your report together, rehearse your testimony, discuss potential challenges from the opposing side. The better you understand the strategy, the more effective and credible your testimony will be. Finally, a word of caution. Avoid talking to the media about your case. Public comments, interviews, or even social media posts can be twisted or taken out of context, and that can compromise the integrity of the trial. If someone wants to hear your side, let them do it in court. Expert testimony is an art. It's not just about being right, it's about being credible, understandable, and professional under pressure. When done well, your testimony can help deliver justice. When done poorly, even the best forensic work can be dismissed. So study hard, know your evidence inside and out, and most of all, practice communicating with clarity and confidence. If you found this module helpful, be sure to like, subscribe, and share it with others in your field. And don't forget to drop your thoughts on today's question. Are courts doing enough to make complex digital evidence accessible to non-technical jurors? You'll find more resources in the description below, including the full video playlist, the podcast series, as well as the textbook on which it is based, The Guide to Computer Forensics and Investigations, 6th edition. Join us for our final module, Module 16, where we'll wrap up the series by diving into the ethical responsibilities of expert witnesses in digital investigations. Until then, stay sharp and stay forensic.